Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
Welcome to the Lex Rex Institute podcast. I'm your host, David Truschel, lead writer for the Lex Rex Institute.
And I'm your co-host, Alexander Haberbush, president of the Lex Rex Institute, and also a lawyer dog. And well, I just mean a lawyer, actually, but I'm not speaking in the capacity of either a lawyer or a lawyer dog today.
Before we begin, please note that nothing in this podcast constitutes legal advice, and all of the opinions expressed are the opinions of the individuals expressing them, not necessarily the opinions of the Lex Rex Institute.
The Lex Rex Institute is a nonprofit constitutional advocacy organization. If you'd like to learn more about our organization's activities or make a donation, please visit our website, lexrex.org. That's LEXREX.org. All right, so what do we got today?
You already sort of spoiled our first segment, but those of you who listened to our first episode will remember the saga of the lawyer dog, which was first featured in our legal hot take segment.
And deemed not to be a valid invocation of rights under Miranda, which,
right.
You know, your right to a lawyer, you got to clearly ask for a lawyer in a way that is
unambiguous.
Yeah, unambiguous. And
ultimately...
Some felt that was an ambiguous way of requesting counsel.
Yeah, a Louisiana court ruled that the suspect in that case who was being interrogated by police had not properly invoked his right to counsel when he said something about wanting a lawyer dog. Now, they chose to read that without a comma, as though he were asking for a dog who is a lawyer, rather than with a comma, as though he were calling the policeman dog, like buddy, pal, and asking for a lawyer. Well... Yeah. We thought that was a pretty straightforward instance of misinterpretation, but one of our listeners, however, directed us to an article in the Washington Post where someone said, basically, not so fast, maybe not so clear.
And in the interest of fairness, we want to give the full context for both when the rights to counsel attach, what a valid invocation to counsel looks like, and then also, you know, what was actually said in this case. So take it away, David.
Yeah, so this is an article by Orrin Kerr, and...
That's an ironic name.
Yeah, I get it.
I don't think it's spelled the same way, though.
No, not C-U-R. Wait, is it C-U-R or C-U... I think it's just C-U-R, not
I think
two
it's 2 R's, isn't it?
I don't...
Maybe.
Hold on, let me look
I can't
this
spell.
Up. Let me look this up. This is going to bother me. Yeah, just 1 R when you're talking about like a mongrel. Anyway, vocabulary word for the day, cur. C-U-R means a dog, especially like a mangy dog. Anyway.
So this guy, you know, this guy's an expert on dogs versus lawyers.
Yeah, dog-related legal issues. Anyway, he said basically that if what the opinion of the court meant was that the use of the term dog in and of itself made it unambiguous, that he agreed that would be ridiculous. But he argued that in fuller context, what they may have meant is that the invocation was ambiguous. That is to say, the suspect didn't clearly ask for a lawyer.
Just to be clear, in order, you know, there's case law, I think it's from Davis v. U.S., I think is controlling law on this, that says that an invocation to the right of counsel must be an unambiguous declaration that that somebody's asking for a lawyer. Mm-hmm. And in that case, I think that, you know, basically what the person had asked in that case was something to the effect of, maybe I should talk to a lawyer. Do you think I should talk to a lawyer? Like a question to the police officers. And by way of analogy, the court in this Louisiana case said that the defendant in that case's invocation of counsel was similar or ought to be treated similar. So, David, why don't you go ahead and do you have the exact quote of what the person asked for when asking for a lawyer?
At least I have what the Washington Post printed. So...
Okay. We'll assume they're not going to outright lie about that stuff.
Right. What they printed technically is not accurate to the transcript because they removed the word dog. So to take that issue out of it, they removed the word dog from it. So I'll read it the way I think the suspect then actually said it, which is as follows. This is how I feel. If y'all think I did it, I know that I didn't do it. So why don't you just give me a lawyer dog? Because this is not what's up.
See, I would see that as very, very different from the language the defendant used in the Davis case.
I'm inclined to agree.
The defendant in Davis was asking a question. He was asking to the police officers, do you think it's a good idea if I have a lawyer? And then essentially putting the ball in their court to decide whether or not they were going to do that. Here, I mean, because of what the guy's saying, I can see why people would say it's similar, but here it's not a question. He's saying, if y'all think I did it, I want a lawyer. In other words, if this condition is met, I would like a lawyer. What I think this invocation of right to counsel does, I think that it demonstrates some degree of ignorance about how custodial interrogations work. You don't have to think that somebody's guilty in order for Miranda rights to attach. But what I read this as, if you're going to be accusing me, if I'm a suspect in this crime, if I'm the sort of person who's subject to right to counsel, then I want counsel.
Yeah.
He may not have understood his Miranda rights. He may not have understood that he was being interrogated. I don't know which aspect he didn't understand. He's not a lawyer. He doesn't have to understand that stuff. He just has to make a clear invocation of right to counsel to the police. And then at that point, right to counsel attaches.
Yeah. I think, to be, I guess, maximally charitable to Orin Kerr here. And, he says it's an ambiguous case in his mind. He doesn't say definitively, no, he wasn't.
I think it's very clear.
I agree.
Very clear.
But, give his reading of it the, best.
Well, and the reason I think it's clear, is because everything else aside, the defendant is not in the position to know if the condition that he set up in his request has been met.
Yeah.
Only the police are in that position. And a statement is judged to be ambiguous or definite based on what the police officers know, since they're the ones who would be violating that person's constitutional rights by denying them right to counsel.
Yeah.
And if they know that they're going to, that he's in a custodial interrogation, they know the condition is met.
Mm-hmm.
So it is unambiguous from their perspective.
Yep, I think that makes sense. What Orin Kerr seems to be getting tripped up by, as I see it anyway, and as you seem to see it, is that it is syntactically a question, but I think it's very definitely...
It's not.
No, because
it is not an interrogatory.
He ends with saying, why don't you just give me a lawyer? So that, that is...
Well, that's not in what you read.
Yeah, it is.
He said, I don't know. I know that I didn't do it, so why don't you just give me a lawyer, because this is not what's up.
Yeah, why don't you just give me a lawyer? Now, so that is technically could be read as a question. I think it's very definitely a rhetorical question meant to function as a statement, which is, give me a lawyer. And I think it takes a little bit of...
There's actually a lot of clauses in that sentence.
Yeah, it's. I think he was...
I think the sentence contains something that on its own could be a question, but the sentence with all of its clauses ends in a period.
Well, as they've chosen to represent it. They could have chosen otherwise, but I think...
These are the undisputed facts as reviewed by the appellate court in Louisiana. So whether or not this is what the guy intended to say on his transcript, I don't think the facts were disputed here. Only the legal point of whether or not this was an invocation of right to counsel was disputed.
That's fair enough.
The record as presented to them ends with a period.
Yeah. And I'm guessing if you could hear his tone of voice, you would agree that that's almost certainly the way he said this. Because if you said, why don't you just give me a lawyer? Because this is not what's up. That would be one thing, but I'm guessing. Yeah,
right.
I'm guessing that's not how he said it, and I'm guessing
that doesn't seem likely.
The transcriptionist heard the tonality and concluded, I think rightly probably, that it wasn't.
I really think that the sticking point for the court, and I think both for Mr. Kerr, is the if y'all think I did it.
Right.
I think the fact that it's a conditional request for an attorney, I think is what's making people say that this is not an unambiguous assertion of the right to counsel.
Yeah.
But like I said, that ambiguity exists solely in whether or not that condition is met.
Yeah.
Which the police know that it is.
Right. Yeah, because otherwise he wouldn't have ended up being charged here, presumably.
Right. The problem with a lot of the stuff like this is, so a case will get to the Supreme Court, a new standard will be passed down for what police are allowed to do when interrogating somebody. Then the next thing that happens is a bunch of lawyers read that case, and they develop programs to train local police departments to comply with whatever the new standard is. And the standard in this case that they would teach to police, as derived from the Davis case, is going to be, it has to be an unambiguous statement. If somebody doesn't request counsel, that's double negative.
Clearly.
But if somebody requests counsel ambiguously, then you say that it's not sufficient, and you keep interrogating that person. So the police, rather than looking for, do I understand this person to be asking for a lawyer, are instead saying, do I understand this person to unambiguously be asking for a lawyer?
Right.
But the whole reason that ambiguity standard is in place in the first place is because in the Davis case, the court reasoned that the police may not have known that he was asking for a lawyer. The fact that something may be technically, logically ambiguous doesn't mean that it's actually ambiguous at all to an observer.
Yeah, that's a good point.
So it's a problem of the way that we train police on this stuff.
Yeah. I think there's a lot about the way boots on the ground police officers proceed that I know drives lawyers insane. And I think this is just
Don't get me started.
Yeah, this is just...
I support my local police, support local police across the country 100%. They are such a necessary part of the way that we currently run government, but a lot of police procedure I think could stand to be improved.
Yeah, there's lots of instances where they inadvertently make things inadmissible because, it comes down to a gap in understanding or training or both, basically. It can cause a lot of problems procedurally, but I think this may have been one of them. But in the end, the courts sided with the police on this one. So,
yeah, well, a big part of it is we've like you mentioned last week, David, we've sort of not de jure, but sort of de facto charged police with being the right people to investigate crimes now.
Yeah,
and they're just not really set up to do that. And when they start doing that, I think you tend to get a lot of abuses, and that's not the fault of the individual officers at all. That's a fault of the fact the system is asking people in a law enforcement capacity to do something that's really outside the purview of their job.
Yeah. Anyway, so that's our revisit of the lawyer dog. I think we still basically land where we did originally, but thanks to...
Actually, I would say even more strongly now.
Yeah. I forget who it was who sent this to us, but thank you to the listener.
The person that sent it was a lawyer, though, so reasonable minds can differ on this.
Yeah. All right, with that out of the way, we're going to get into some news, or actually this week, maybe more accurate headline review, because we do have something we're going to talk about that isn't technically news. But first off, you wanted to bring up something. I haven't really been briefed on this, but a new development in the whole January 6th committee saga storyline.
Yeah, specifically the Eastman litigation over the records over which we are claiming privilege that Congress wants us to give them anyway. As I mentioned last week, we had just filed our brief. We received Congress's opposition brief this Thursday. They, of course, object to our invocation of the work product privilege, and they really didn't like the section where we claimed that work product privilege could be invoked for legislative. So I guess what you got to know about work product privilege is it applies when in anticipation of litigation. And they said that this representation of Donald Trump was not a matter that was going to be litigated. It was something that was in front of Congress, the vote count on January 6th specifically. Our argument was that because states can decide whether or not to decertify electors, because Congress can decide whether or not to decertify electors from states, that involved questions of fact. That's a case or controversy, therefore it's litigation. They basically said, no, it's not litigation because we think that what you were trying to do there wasn't good, and people only do good things in litigation, I guess was sort of the implied argument there. Not terribly strong, but that's the way they've responded. So that's still an ongoing matter.
Well, I'll have to take your word for that characterization of it because I haven't read anything about this.
Might be a little bit uncharitable, but...
Yeah.
But it amounts to basically that. They said that an attempt to corrupt a proceeding is not litigation. All right, but obviously Eastman does not think he was trying to corrupt that proceeding, whether or not you do.
That's what we call begging the question.
Another new word for the day, question begging.
Yeah. And all right,
when your premise is the same thing as your conclusion.
Yeah, I'm going to take a few seconds on this one just because this is one of my pet peeves, and I think it's sort of a losing battle. I think it's already too far gone in common usage, but I see a lot of people say beg the question when what they mean is raise the question.
Or
and
demands
so anyone who's
the question.
Anyone who's listening to this, if what you mean is the information you had just presented introduces a new question, or prompts a new question in your mind, that is raising a question, not begging a question. Begging a question means assuming in an argument that your conclusion is correct from the beginning, and then presenting that as evidence that your conclusion is correct.
Can you think of an example of begging, of question begging?
So
all the ones come to mind to me are all legal ones that are probably too esoteric.
Yeah, those are probably the most obvious ones, but in its bluntest form, and obviously no one would actually say it this way, but this should just like sort of show what it is. Excuse me. Wow, tongue twister. If you were in an argument about which is the best superhero, and someone said, well, it's obviously Superman, and you said, why? And they said, well, if Superman weren't the best superhero, how could he be the best superhero? That is sort of at its most naked question begging.
Or say it's an argument between is
best.
Superman the best superhero or is Batman the best superhero? And then the person arguing for Superman says, well, Superman has more powers, therefore Superman's a better superhero. That basically is the difference between Batman and Superman. That's the point in contest.
Yeah, that's fair. Yeah, and that's probably a little more realistic. Very few people would just like directly beg the question the way I just did. But,
like if you're even having the argument of which of these two people is better, then the point in contest is whether superpowers matter.
Basically, yeah. That may irritate some real DC Comics fans out there who would say, no, you're missing the subtleties of the character, blah, blah, blah.
All right.
Sure, fine. But
I'm just saying,
this isn't really...
If you've narrowed the question down to these two guys, a major point in conflict is going to be whether or not superpowers matter for being the best superhero.
Is it cooler to have a bunch of superpowers, or is it cooler to not have superpowers, but nevertheless
have a bunch
still...
of money.
Yeah. A bunch of money and intelligence, blah, 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 whatever. Anyway, we're getting in the weeds here. And
how much money do you need before you can be Batman? Like, when will Lex Rex get to the point where we can have a Batman?
I think never, because that would definitely not please the IRS if we
I want to give somebody a figure, though. So if we have a listener that wants to make a contribution to enable the Lex Rex Batman, I want to tell him what that number is.
Well, the Wayne Corporation, I think, is definitely shown as being at least like worth tens of billions, probably upwards of 100 billion. So let's call it 100 billion.
No, we can do it. I think we can undercut them for sure. Let's say 10 billion.
Okay. Fine.
We're a lot more efficient than the Wayne Corporation.
Yeah, we don't have to waste a bunch of overhead on keeping a massive subterranean complex secret.
None of us have butlers.
Yeah. Yet.
Anyway. I'm saying we'll make getting Batman a higher priority than hiring an Alfred.
Mm-hmm. Yeah. Anyway, I think we're a little bit off the track here. So
a little bit.
Anyway, all that to say
that
that's one of my personal pet peeves is misuse of that phrase. Like I said, I think it's too far gone, losing battle. But
so don't do it, folks.
Yeah, don't say beg the question when you mean raise the question. Anyway, let's move on to the next thing up. And this is another sort of a revisit, not quite, because it actually is about a different law. But a couple of weeks ago, we were talking about a Texas state law that got at least temporarily not upheld, but allowed to continue in enforcement, basically, by a circuit court.
Reversed the injunction against it.
Yeah. So if you want to know the details, go back and listen. I think that was a couple weeks ago. But basically, Texas had this
episode, so it's getting increasingly difficult to listen to all of them, but I think you can still do it at this point. So
yeah, there's only a few. Anyway, Texas had this law imposing limits on social media companies above a certain size.
Florida turns out has a similar one, or had a similar one.
And not necessarily similar in all the details, but basically aiming at the same goals. Basically to prevent social media platforms from censoring content for viewpoint, basically. So preventing, this is rightly or wrongly has become a bit of a political point. Lots of people, especially conservatives, feel that Facebook, Twitter, etc., moderate comments, impose, shadow bans, otherwise manipulate the algorithm to minimize certain kinds of political posts.
I always thought of free speech as sort of a left-wing issue, like the free speech movement at Berkeley, and it's conservatives traditionally try to police public morality. That often includes free speech type things. It's interesting that it's been cast as a conservative one in the past few years, but I think that's pretty much only because these social media companies tend to be banning those viewpoints. Nobody really likes their opponent to speak.
Yeah, that's true. And that's one of the things that I think almost everybody will, in theory, say that they value freedom of expression, freedom of speech. But then, it really comes down to, okay, but that speech doesn't count. We talked about that too, where a lot of people seem to be under the impression that in the U.S., hate speech is not protected speech. Which, unfortunately for them, it is.
That's actually, I was going to do an Ask an Attorney video on that would have come out last Friday. The internet at our office went down Thursday evening, and I've not had a chance to record that yet, but that's probably going to be the next Ask an Attorney video. Is going to be on the subject of hate speech.
Okay.
So I don't want to get too much into the weeds on that.
Yeah, so we'll save some room for you. But anyway, freedom of speech is one of those things that most people are a big fan of in the abstract, but often push comes to shove when you bring it down to particular instances, they may not like it so much. And I think in some ways this turns out to be one of those dividing issues. But Florida introduced this legislation.
Because it's got to apply to everybody or it applies to nobody.
Exactly.
It's just when you get your guy in power, you can ban your opponent's speech that way. I mean, it's outrageous.
Yeah, political football.
Yeah.
We'll get into some of the specifics of the Florida law in a bit because I think some of them are very interesting. But basically, different circuit court, I believe it was the 11th Circuit, that's what I have in my notes anyway, blocked most of this law. They ruled that most of it violated the First Amendment by imposing restrictions on the free speech of these companies. They left some elements of it in place, but very little.
Yeah, I found that interesting because I don't think you even get to the First Amendment issues on this. I think that this law is really easily overruled on the grounds of preemption, possibly even dormant commerce clause. Even the fact that I'm not sure that it's clear that Florida has jurisdiction over California tech companies. You know, there's sort of a right now. There's a huge mishmash of case law in terms of what, because the standards for whether or not you can exercise jurisdiction over a corporation is whether or not they have there's a whole test, but basically whether or not they've extended their commerce to the people of that state. So traditionally, like if they open a headquarters in that state, if there's an ad campaign in that state. Internet, it's a little bit different because it's sort of in the ether. It's not, actually on the physical ground of, or I guess the physical swamps of Florida. So there's ground
that
there,
may be
right?
Slightly unkind to Florida.
There's some ground there?
Parts of it, there's plenty of ground. Parts of it, it's, only 80% swamp.
Okay, well, neither in the grounds nor the swamps of Florida have they put any kind of advertisement. So right now, this is still sufficiently new. I know the internet's 25 years old at this point in terms of general widespread usage, but to courts, that's still really, really new. So there's not a consensus about what it looks like to put yourself subject to the jurisdiction of a state in terms of that analysis. But so laws like this, I think they've got to be pretty much ultimately symbolic in passing them, because there's no guarantee they're even going to be upheld in terms of the jurisdictional issue.
Yeah, that's one of the things I think is interesting and in many instances sort of unfortunate, is that a lot of these things that get a lot of legislative support tend to be because there's a groundswell of public opinion about them that drives representatives to say, oh, I want to do right by my constituents. They're really passionate about this thing. We'll do something about it. But that can lead sometimes to poorly crafted law, because often public opinion isn't accounting for some of the nitty gritty on the legal side. Like, do we even have the jurisdiction to do this? And I think that's one of the live issues here. It's been a very hot issue, especially among more active, people with a more active interest in politics, I think, especially Republicans of late, have been very concerned. Again, I'm not going to weigh in on whether I think it's right or wrong.
Throwing the former president off of social media, that's a bold move. And I know at least Twitter did that. Several other platforms may have done that. But as soon as you do that, you're certainly going to animate that party's platform. I'm sorry, that party's base.
Yeah. Again, no political judgments, but I think it's very clear there's been a lot of heat around that issue and maybe a little less light. And it led, I think, to some. Yeah. Let's talk about some of the specifics of this law, because some of what it purported to do is, I think, pretty extreme. So let's run down a quick list that I made here. Among other things, it would have prevented social media sites from deplatforming, and they define that basically, limit access for more than a few days, basically. That
was just for candidates for office, right?
Yeah, anyone running for statewide
so Florida
office.
Candidates for office.
Yeah, but with pretty hefty fines. So if you're running for statewide office, so running for, Senate in Florida or governor, something like that.
State Senate.
Yeah.
To be clear.
Fines up to $250,000 a day. And if you're running for a different office, a non-statewide office, up to $25,000 a day. And
now, did it define candidates?
It did. And I forget.
Did it mean somebody who's actually qualified for the ballot? Because anybody can call themselves a candidate.
I'm fairly sure that was what it did. It definitely did provide a definition for a candidate.
So
and it also
ends up giving specific protection to political parties then. Because, I could create a party, call it the Free Speech Party. We run 10,000 candidates in our elections in the state of Florida.
Yeah.
We're endorsing all 10,000 of them.
Yeah, and if you're qualified for the ballots, then that's suddenly a lot of people that this applies
Right.
to.
It's just a matter of, we have like a scratch each other's back thing with people who sign the, because I think it's probably, something in the neighborhood of several tens of thousands signatures you need to qualify. We just say, you have to sign the petition for everybody else if you want to qualify to get on our list of candidates. Everybody gets enough signatures, we're all on the ballot.
Yep. And one of the things I thought was interesting, because on the one hand,
I don't know how Florida law works for ballot qualification, but it certainly does seem like the sort of thing that
you would need to do.
May not have been that well thought out. You don't want to give special rights to politicians. No. Politicians should have the same rights the rest of us do.
Yeah. I think one of the questions that prompts is, okay, so how do you know someone's a candidate? And they thought of that and came up with a method for this, but it's one of those things where it solves one problem and I think creates a massive different problem, which was Yeah,
because the fundamental issue is you're giving rights to certain people that other people do not have.
Yeah.
And I think politicians are about the last group that you should try to give extra rights. Yeah. They're the people that are making our laws.
But one of the things this law would have done is require all these major social media platforms to create a method by which you can identify candidates who would qualify for this protection. So you're saying,
which obviously imposes expense upon those platforms.
And probably massive expense, because you also need someone to vet all of those candidates and say, okay, they applied for this status. Do they actually qualify for it? How do we know? That's a massive headache, especially if you're, up in Silicon Valley. You don't have anyone on the ground probably in Florida to, talk to local offices, and, you need to figure out a way of getting all this information in a timely manner.
Again, it's not even clear Florida has jurisdiction over these companies.
Yeah, that's a major point.
It could be. I don't know if this is true, but it could be the case that not a single employee of one of these companies has ever been to Florida.
Yeah, unlikely, but
it's on the internet, so you could still access it from Florida.
Right. And presumably they're not keeping their main servers in Florida either. But
you don't want those to sink into the swamp.
No, that would be, or get eaten by a gator. Anyway,
do gators eat servers now?
I think they'll eat pretty much anything that looks,
well, they ate Captain Hook's hand.
That's true. Yeah, that's very true.
Yeah.
Would have been pretty painful because they don't actually have sharp teeth, so they must have just sort of like
no.
crushed
They twist when they bite things.
Yeah, so just
they twist so they can rip things apart.
Yeah, nasty. Anyway, so that's one thing it would have done. And as we said, I want to underscore, for statewide office, they were going to fine these platforms $250,000 daily for having deplatformed, quote unquote.
That's a lot.
Yeah, that's if you did remove a candidate and then you don't reinstate him during his campaign, you've suddenly cost yourself millions of dollars this way. Again.
Yeah, and obviously, these are out-of-state corporations.
Yeah.
The Florida government has an interest in finding these companies liable for violations of this law.
Yeah.
Because that's money coming from out of state into state.
Yep. Supplement to your tourism revenues.
Sure. I mean, just as a matter of fact, they are an interested party in this.
Yeah. So anyway, there was that, and as part of that, requiring them all to build this system to identify candidates. They also would have required the platforms. This one I thought was pretty interesting. They would have required any platform that is offering free advertising, and they went on to define that in pretty specific ways. Basically, generating content about this person in a way that could feasibly promote them. Would have required them to notify the
That's
candidates.
what the algorithm does, isn't it?
I think in many
all of these
instances.
social media platforms have an algorithm that prioritizes where you're going to fall. That's advertising, because that's making sure that more people will see what you've done.
Yeah. I'm pretty sure their definition was crafted such that it would include that sort of algorithmic prioritization.
I don't see how you could possibly exclude that.
I agree.
That's how they're choosing what to show you.
Yeah. So anyway, would have required them to notify those candidates, which in practical terms probably means anybody who starts to get pushed by an algorithm, which is largely autonomous. You'd have to notify that person of that. Which means monitoring. And
I'm not even sure they keep track of what, X candidate's posts have been seen this many times more than this candidate's.
Yep.
Here's the proportion that was organic interaction, and here's the proportion that was spurred solely by our algorithm. I don't know if you can even identify that, because a lot of these algorithms tend to amplify existing organic trends.
Right.
If 100 people have clicked on something, the algorithm says that's an important thing, and then pushes it higher up so more people see it.
Yeah.
That's, on the one hand, that is the company deciding to prioritize or promote that content. On the other hand, they're not the ones that identified the content as being worthy of promotion.
This is one. Okay, so thus far, this next one is the only one that I would actually prefer to see as a feature on these platforms.
A lot of this stuff is stuff I would like.
Well, I don't particularly care if they have to pay Florida money or
that's
not.
important to keep in mind here. Our analysis does not have to do with our personal preferences in terms of what sort of social media platforms we would like to be on.
Yeah.
That's not really what the law is about. The law is about doing justice to different people. So we're looking at it from that perspective.
Yeah, this next one is one though that if if you asked me and it was if it were a legitimate thing to say that legal opinions, legal decisions will be calibrated just to my preferences, this is the one I'd be unambiguously yes, but I still think it's illegal for them to do it.
Which one's that?
They would have required social media platforms to allow you to opt out of their algorithm presentation of posts. So, the way you go on now and it shows you the things it prioritizes and allows you to just view
the
things
algorithm we were just
chronologically.
talking about.
Yeah. So I have been...
David, I'm going to go a step further. That's not your personal preference. I would say there's actually a moral precept here. A company is acting immorally if it provides digital content and doesn't give you any ability to sort that digital content.
Yeah.
So, that's a general moral precept, certainly, but as a legal proposition, it's their company. I'm not sure they ought to be forced to do it.
I'm not sure I think it's completely philosophically valid to say that's a moral precept, but I would sure like it.
I'm not going to say to what extent, what percentage here I'm joking and what percent serious I am.
Fair enough.
I'm at least some percent joking.
Yeah. Anyway, but that's what I really miss about the early days of all the social media stuff was when it was just you went on and they hadn't thought through all this stuff. They hadn't developed these means to target you with different kinds of content. And you could just see, well, at 3 a.m., this guy posted this. He was up late. At 6 a.m., this person posted this. They were up early.
Back in the day, they were all people from data type fields. They were computer programmers and people who had worked in statistical analysis, all that kind of stuff. And they were like, oh, well, more information, more content, the better.
Yep.
And only later on did they get people from, like design fields that said, oh, that's visually very complicated. We can't have that. Or people from, I guess more customer-oriented fields.
Yeah, no, it drives me nuts. I read Twitter like when I'm standing in line and bored, and it's just sort of a reflex at this point. Probably not a great one, but it keeps me entertained. But it drives me crazy. A few years ago,
it's designed to keep you doing that too.
Yeah, well, they introduced this thing a few years ago where you start at the top and you start scrolling down, and it's mostly chronological there until you get to a certain point, and then it says, in case you missed it, and then it starts feeding you back like mostly the same stuff you've just been scrolling through. It drives me absolutely insane. So, like I said, I
don't use Twitter, but that sounds obnoxious.
Yeah. If I were in charge and it were not...
What's the point of that? ...completely
tyrannical to just impose my desires on a company, I would say, yes, do this. But the fact is that would be tyranny, and I'm not in charge, and that's probably better for American society in general that I'm not. So I don't think Florida can really do this, but they wanted to.
Again, like basically the service that Twitter, Facebook, the rest of them offer, their service essentially is the algorithm.
Yeah.
What makes Facebook different from Twitter is the way in which they prioritize posts that people see. They also, there's content differences and whatnot, so on and so forth.
That's
largely what makes the platform is the algorithm. So if anything is a part of these companies' free speech, it's the algorithm.
Yeah.
Yeah. I hate it. I hate what they have to say, but because I hate the algorithm. But like I said when we started this segment, free speech has got to apply to everybody, or it means nothing.
Yeah. So anyway, there's that one.
Even stupid algorithms that feed you the same thing twice in a span of 5 minutes.
Yeah.
If what they want to say is incessant and repeats the same thing, well, then they have a right to say it.
Yep. Okay. So back to the other details of the Florida law, though, it would have stopped social media and a lot of this stuff, like where it imposes restriction on their ability to ban or shadow ban or blah 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 whatever. There are exceptions for obscenity, which has a legal meaning. We won't get into all the details there. But anyway, basically, if you're posting something genuinely heinous in some way as recognized by law, none of this applies. But it would have stopped social media platforms.
Shocks the conscience
is
one of the standards there.
Yeah.
I know it when I see it as the
famous phrase.
Better one, in my opinion. Yeah.
But it would have stopped social media platforms from deplatforming, shadow banning, whatever blah blah blah, all these different terms, any journalistic enterprise, and they basically define that rather as a publisher of a certain volume or size, etc. So if you've got enough content,
so again, it's about how many people they reach. So again, they're giving protections to people based on how many other people agree with them.
Yeah, and
okay. I don't. Just as a social policy matter, I think that approach is very dangerous.
I agree, and one of the things I think they're concerned about
You should not be catering to the loudest voices.
Yeah, and I think one of the things that this law is concerned about happening is that exact thing. Namely, they're concerned about only preferred media being given access to these social platforms.
They're just saying, but the state has changed it to, rather than preferred by Twitter, to preferred by the general public.
Right. So. But that still means
that's a bit better. But
yeah, it may be a wiser way of doing this, but it still means you're picking and choosing among people who are trying to present content to you in some way or other.
Right.
Now, so there's that. It also would have required, and actually some of this stuff is what the circuit court actually upheld. So it imposes certain requirements for these social media platforms to be very public, very open, very thorough about explaining what their standards are, under what circumstances someone will be banned, shadow banned.
And that makes sense.
Yeah.
That's not a free speech issue. That's a contract rights issue. By using their platform, you're agreeing to contractual terms.
Yeah.
You have a right to know when you're found in breach of those terms.
Yeah. And here's one, though, that you'll be able to speak to the legality of this better than me. It certainly seems like it's imposing a very heavy burden, though. So that it would require them to accompany every individual action of banning or shadow banning with a thorough investigation and explanation of how they reach that decision.
My opinion on this is that these social media companies have essentially been shirking that burden, which already should have existed. Mm-hmm. Every time somebody signs up to use a service like Twitter, Facebook, that's a contract.
Yep.
Contracts are something that requires at least some degree of scrupulousness and attention from both parties. If you're bound to somebody else by contract, you have to at least ensure that the terms of that contract are being followed. Mm-hmm. I think that's largely been ignored by these companies. They don't really treat it as a real contract, except for, it binds the other person to them, but they don't think that it binds them to their users in any way.
Yeah.
And so I think that's just compelling due diligence on their part.
Okay. Anyway, and, as with the Texas statute, the upshot of all of this is it authorizes individuals who feel that the social media platforms have violated any of these things in respect to them. So if you feel you were improperly or inadequate, something went wrong and you were banned or shadow banned and you feel you shouldn't have been, or they didn't handle it right, it allows you to sue them for damages. And that was,
How do you calculate damages on this?
I think they defined it.
Is it just standard?
I'm pretty sure that, they had a little fee schedule basically, but I would have to.
So it's statutory damages.
I think so. Yes.
Interesting.
Let me pull that back up to $100,000 in statutory damages per proven claim.
Wow.
In addition, actual damages.
So that's a statutory cap then. You still have to prove your actual damages.
Yeah.
Okay, so that's standard common law. You prove how much did it harm you.
Yeah, and so I'm guessing that probably is, things like loss of revenue from people clicking on your content or whatever if you're a media outlet.
Yeah.
Blah, 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 etc. But, so this was what the law was designed to do. This is what they put in the actual bill. The 11th Circuit Court struck down most of it, basically with the exception of those disclosure requirements.
Just to take a step back, looking at the requirements this law imposed, it's very, very clear that Florida was taking the position that these social media companies do not have a right to free speech, that they must be treated or should be treated as common carriers.
Right.
How do I know that? Well, because as we've gone through, it's very, very clear these laws are not respecting a right to free speech for an entity that would have that right to free speech.
Yeah.
Now, I'm not going to voice my opinion on whether or not social media companies ought to be treated as common carriers. I think there's a very strong case that maybe they should, but that's a tough question, and it's beyond the purview of what we're doing today. We may talk about that in the future. Yeah. But long story short, the court ruled we're not going to treat them as common carriers. Yeah. Therefore, the regular rules of free speech apply. And we're going to overrule a lot of this on the grounds of free speech. Yeah.
And as you alluded to earlier, we both thought this was an interesting element of the opinion of the court that they put out. They did seem very eager to sort of skip over, that may be a slightly pejorative way of putting it, to
I think it's an accurate way of putting it.
It may be accurate, but it can be both. But
they decided to look at the free speech issues predominantly,
rather than
instead of what I would call jurisdictional constitutional issue. Well, jurisdictional issues of preemption, Commerce Clause, really those two.
Yeah, and so they basically said, the group representing these social media companies, they wanted us to look at the issue of this being preempted by federal law. And we instead decided to treat it, exclusively under the heading of First Amendment rights. And they said it basically in a footnote.
So, just so you guys are aware, I think people probably don't know this, but just so you guys are aware, judges are only supposed to rule on the matters that are before them.
Right.
And if there's a solid basis for ruling on a case that, by ruling on this issue, you don't even get to some of the other weightier issues, you're supposed to rule on that one first. And the way that this analysis works is if there's both a constitutional challenge and a statutory challenge, you go with the statutory challenge first. And if you find that the law does not meet scrutiny on the statutory challenge, in other words, it's invalid for whatever statutory reason, you don't get to the constitutional challenge. As we've mentioned before, our law kind of exists in a hierarchy with the Constitution at the top. And like with any other chain of command, you raise questions up the chain of command. You don't start at the top, you start at the bottom, and only if you've gotten through all these levels do you ever get to the top.
Yeah.
Well, the question of federal preemption, which I've alluded to several times already, but is basically whether or not Congress has articulated a scheme for regulating in a particular area of law. And this is implied preemption, by the way. There's also express preemption, where Congress has said, states can't make laws about this. But for implied preemption, if Congress's legislative scheme shows that they intended to be the only people making laws about a certain thing, they didn't want states making laws about that, then whatever the state, when a state does try to make a law about that, that law is implicitly preempted by federal law pursuant to the Supremacy Clause of the Constitution. What the court said in this case, and I find this crazy. I think this is a crazy argument. Anybody out there who disagrees, feel free to contact me. That's fine. I like disagreement. But they said that both of the questions, the free speech question, so the First Amendment question, and this preemption question were both constitutional questions. Therefore, they could deal with the free speech one instead.
Yeah.
That's crazy to me, because even though preemption operates by virtue of the Supremacy Clause of the Constitution, the actual law on point is the law preempting the state one.
Right.
That's a statutory question.
Yeah. And it gave
that was totally boneheaded, in my opinion.
Yeah, and it gave the impression, partly because they made that argument in particular, where they said, we know normally you start non-constitutional and then go to constitutional, but really all the arguments were constitutional because of the Supremacy Clause. They made that little argument in a footnote, which gave it a very sort of tossed off.
If that's your rationale, if preemption always and necessarily must be a constitutional issue, then all legal issues are constitutional because all laws existing under the United States must exist pursuant to the Constitution's authority.
Right. It gave the air of a little sleight of hand, where it's like, we could do this, the normal way, the right way, but what we're really interested in is making a ruling on how this relates to free speech rights, because that's sort of a bigger thing. And
I'm very cautious to ever criticize the motives of a judicial officer, because I don't think that's right. We owe them the benefit of the doubt that they're being consistent with their judicial philosophy at the very least. But what I will say is, if a judge were more interested in courting the media or in making a name for himself in the news than about having a judicially consistent and legally valid opinion, he might act similarly to this.
Or I think, to be a little, maybe a middle ground in terms of the charitableness with regard to the judge, maybe he just thought this was an important free speech issue that should be settled as soon as possible. But
that's what I'm saying is if that was his motivation,
that's still not good. I get that, but
no,
it may
as a judge, you're supposed to rule on the basis of the law, not what you think is important.
Right. And the
voters get to vote on what they think is important. Legislators get to legislate what they think is important. You don't get to do that as a judge.
Yeah. We've said it before. We'll probably say it many times again, but in many ways, all this legal stuff is really just a series of technical questions about order of operations almost. And in this case,
and he got the operations wrong.
Yeah.
He did the addition and subtraction before he did the multiplication.
Yeah.
Because he said, well, they're a lot like multiplication.
or just I know that if I do this the right way, it ends up being one of those trick questions where it's like something times 0. But I really like 9 times 7. I like that equation. It's fun to me, and I want it to end up as 9 times 7.
He didn't say that, but
yeah.
But you guys probably listening to our podcast are probably frustrated that we're not really talking about the substance of this law much at all. We're getting in the weeds about technical, what you guys might pejoratively term minutia, and that might be true. Let me just say, sort of as a broad umbrella thing to keep in mind when talking about this subject, I'm largely sympathetic to the idea that social media companies have far, far too much power in our political order, and that we've got to find some constitutionally valid way of keeping that power in check. I think Florida really picked the wrong way to do it.
Yeah. Yeah, and I guess good point to just sort of reiterate the general mission statement, not only for the podcast, but for the organization. We are not intended to advance political goals, political causes. We all have political opinions, of course, individually, and most of us tend to have fairly similar ones. But that's not what we're here for. What we're here.
That's not true. We've got. Well, I'm not going to name names, but there's a variety.
I said mostly. I put it at like 60% similar-ish views, but
it's probably true.
Yeah. But that's not what the point is. That's not what we're here for. And if you could be any number of points on the political spectrum, if we think you have a valid case at law, we're here to help you with it.
Yeah.
So anyway, all that to say.
And I think there are good, solid, legal, non-political reasons why having excessive power in the hands of social media companies is a very dangerous thing for our republic.
Yeah.
So I'm not saying that as a political statement. I'm saying that as a legal one.
Yeah.
However, given that we want to curtail the power of social media companies, because like I was saying, even if this had been upheld on free speech grounds, even if this judge had said, yeah, I'm going to make the leap and I'm going to classify social media companies as common carriers so they have no free speech rights, I think this law fails for 3 other reasons.
Yeah. Yeah, you should never have gotten to that issue if you'd been...
No.
Yeah,
and then even if the law ends up getting upheld for those other reasons I mentioned, it's still probably not going to be enforceable because there's still the jurisdictional question of whether or not Florida courts can exercise jurisdiction over California companies that have never...
Yeah, unless suddenly...
at least explicitly extended their services to Florida.
Yeah, unless suddenly Facebook or... Well, it's Meta right now, Meta Inc. or something like that, or they changed their name to something.
Google's Alphabet now.
Yeah, Google's Alphabet. I'm pretty sure Facebook rebranded to Meta. Anyway, whatever. Unless one of them suddenly decides that they want to be headquartered.
There's an athlete called Meta World Peace, isn't there? Maybe
but he spelled it differently. I'm pretty sure it was like an Arabic word or something. In his case, METTA, not META. Used to be Ron Artest.
Well.
Anyway, that's really not relevant here. What I was saying though is, unless suddenly one of these companies decides they're going to start, being headquartered in Tallahassee or Jacksonville or something, it's doubtful that Florida could really have done anything about this anyway. But
or if they put up billboards in Florida saying join Facebook, then Florida's obviously got jurisdiction over Facebook.
Yeah,
they probably do.
I'm doubting.
Again, because it's internet, I can't give definite statements on this stuff. Yeah. Right now, our law is a total mishmash across the country for how courts treat it.
Yeah,
so I'm not going to say anything definite about that.
Empirically speaking, I don't think I've ever seen a print ad for a social media company in any format. Pretty sure it's
they don't generally need to.
Yeah, because if you're the kind of person who would use an online social media platform, you're probably online more often than you're looking at billboards. So it's
now if we were talking about Netflix, so Netflix is a different issue because remember they mail out CDs and they mail out CDs across the country.
They may have stopped doing that.
So
I'm not sure if they're still doing the.
I think they still do.
Maybe. You could convince me.
Even if they stopped doing it, they've still at some point voluntarily put their product into the stream of commerce in those states, and then also. I guess that the reason that Netflix is able to stream so fast when you watch something streaming on Netflix is it's not shooting you all the way back to a server in California or wherever Netflix is based when you want to stream something. Netflix will partner with local ISPs and they'll put their boxes with hard drives in them at the local distribution center for internet.
Yeah.
And then you're actually just having to go, at that point, maybe a mile or so to get access to their movies and TV shows.
Yeah.
Well, that very obviously is engaging in commerce in the state of Florida.
Right.
I don't know if Facebook and Twitter are doing anything like that. I don't know a ton about the IT situation for these companies.
Me neither.
I don't know if they, install their own servers or if they piggyback on other people's servers in exchange for fees. I don't know how that works, but my bet is Florida legislators probably know a lot less about it than I do because they're legislators and they tend to not understand matters of the demon box.
That's another old reference. You can find that in one of our episodes. It's not probably worth it just for that phrase, but if you're really curious.
You don't want to get a really controversial law like this that even if it gets upheld is unenforceable for jurisdictional reasons.
Right. And
there's certainly a pretty good chance that it would be.
Yeah. Anyway, so that's the Florida matter. I'm guessing we're probably going to end up seeing something at the Supreme Court level because as we said, it's not just Florida. Texas had this. I think other states are working on similar things. I'm guessing we're probably going to see the Supreme Court have to take on something like this at some point. But for now, Florida got to know.
Yeah.
All right.
Yeah. And just to be clear, even if a federal law had the same details as this Florida law, it would be I think it'd still have a lot of issues, but it'd be a lot more enforceable. Really, the main issue I see here is that it's a state trying to do it.
Yeah. All right. So as I sort of mentioned in brief earlier, one of the things we're going to talk about today isn't really news. It's not, not a report on an event or anything like that, but something that I came across a little while ago. We ended up posting it to our Facebook page. You can see it there. But it was an essay written by a guy named Angus McClellan for the website Law and Liberty.
It's a good site, by the way. They have some good content.
A lot of stuff that is a little off the track for us, but interesting stuff. I can give a personal recommendation. But anyway, he wrote this piece basically as a sort of call for all people who take an originalist view of constitutional interpretation, which would include us as an organization, to sort of rally around a unified methodology. So
yeah. So that's I think one of the things people don't really know is that originalism is a very broad category.
Yeah.
There are lots of different kinds of originalists. And I guess Angus McClellan doesn't like that. So what does he suggest?
Well, he says, and this calls for some qualification because he says, at its root level, we should all agree on what he calls the Blackstonian method. So basically the canons of interpretation.
William Blackstone.
Yeah, set out by William Blackstone, who is
and
probably...
if you've watched much of our content, we're a big fan of that guy. Not so much because, we just personally like him, but because he was the legal authority at the time that the Founding Fathers were writing the Constitution. There's sections of the constitutional debates where they will actually look things up in Blackstone's commentaries to see how they worked. He was the authority on how the law worked at that time.
Yeah. So you had a question about how something was supposed to work. You're like, not quite sure how this goes. He'd be the person you would turn to, specifically his work commentaries.
Commentaries on the laws of England, which were sort of the third such work that had been written, or third major such work that had been written in the history of English law. First was by Bracton, I think I want to say 1100s, and then obviously there's the one by Cook. And then Blackstone comes along, and he wrote, I think in the 1750s, and was still very, very influential in the English colonies. Edmund Burke, in his speech on conciliation with the American colonies, mentions that as many copies of Blackstone's commentaries had been sold in the American colonies as were sold in England, which is, given the population difference and wealth difference, and more specifically the number of
shipping
printing
costs.
presses difference. That is a huge statement. So very, very popular in the colonies.
Yeah. Anyway, so he says basically we should follow what Blackstone says, which is this, multi-phase method. But he makes a particular recommendation for at the point where you get to...
Especially because all of the Blackstone commentaries that were printed in the colonies would have been bootleg copies. So they, assuming they weren't bootleg copies, that means they were imported.
Yeah. Yeah.
But I think they probably were bootleg copies. So
probably a lot of them. But anyway, so McClellan
they
says...
cut out the part about intellectual property.
Yeah. So McClellan says, when you get to the point where you're considering precedent, basically, so you're looking at past decisions for guidance, you should always start with what he calls contemporaneous construction. So in other words, precedent from...
Which, that principle's sound.
Okay.
That I have issues with his application of that principle. That principle is sound.
Okay. But anyway, basically what that would mean is rather than looking at the most recent precedent from your point of view, what the latest decisions have been, the first place you look is at the oldest applicable precedent. So the earliest court records.
That's the application of that principle.
Okay. All right.
So, yeah. So a contemporaneous statement. Is that what he says? Contemporaneous.
I believe the phrase he
statement,
uses is construction. Contemporaneous construction.
Contemporaneous, construction is referring to, I think it's the third item, might be the fourth item in Blackstone's canons of statutory interpretation. So I just briefly, I want to kind of explain what that is. Basically, Blackstone is giving a how-to manual, at least in part of what he wrote, giving a how-to manual on the interpretation of the law. And because you got to have some kind of method when laws are ambiguous, right? So what he says is, very first thing you look at, obviously, is you look at the words of whatever a law says. So applying this to the Constitution, you'd look at the words of the First Amendment. And he says those are to be understood in their usual and most known signification.
Yeah.
Obviously, that's within a particular art. So he says, again, terms of arts or technical terms must be taken according to the accepted or learned use in whatever trade they're in. So legal terms would be construed in their generally accepted legal usage.
Yeah.
And then he says, if you can't resolve an ambiguity from doing this, from just looking at the words of what something says within their context, next you'd look at, so he says, when words are still dubious, next thing you'd look at is their context. So you would look at the words that surround them. If this section of the Constitution is talking about powers of Congress, even if it's not clear this thing's a power of Congress, we could look at it in light of the other things that are being discussed. That might give some light about what it means. So next thing he says you look at is the subject matter. So if a statute has a really broad statement, so say that it regulates something like the purchase of food, and we know all of these regulations are food regulations, and someone mentions something about corn. Well, it's probably not going to apply to a display of Indian corn that somebody puts up for Thanksgiving, because they're not eating that. So again, it's about outside the subject matter of the legislation. And the next thing it says to look at is the effects and consequences of the rule. What that basically means is if the effect ends up having some kind of logical absurdity, or so like the example that he uses is a law that says whatever drew blood in the streets should be punished with the utmost severity. And then he says, yeah, obviously that doesn't apply to surgeons drawing blood. That means dismembering people, stabbing people with a sword. So that's the effects or consequences that you look at. It's not that you're just looking for good effects or bad effects, but you're trying to gauge what the purpose of the law is from those effects. And then lastly, he says that you would look at basically what he calls to be the reason behind the law, the purpose for which it was written. You could call that the spirit of the law. That's the very last thing you look at, only when the law is still ambiguous at that point. And people are way overly broad in their application of this. It doesn't just mean the general thing the law happens to be about. It means, so the example he gives was Cicero talks about a law where a ship was cast onto the land by a storm. And the law said that when that happens, you forfeit all the property within that ship. So then, an instance came up where there's a dangerous tempest and all the mariners forsook the ship except for one sick passenger. And then that sick passenger stayed in the ship when it ran aground. So the question was, does that sick passenger come into possession of everything in the ship? Because the ship wasn't actually forsook. Well, obviously, that was sort of outside the bounds of what that law was talking about, so he says that it wouldn't apply. But those are the different steps that you go through. What Angus McClellan is talking about is, I think he says this refers to the subject matter step.
I believe,
is
that's
right?
the heading. I'm pretty sure that's the heading he sort of stowed this under.
Okay. So he's saying, and again, just to remind you guys, subject matter was the one where we talked about, if a law is about food regulation, probably not going to regulate display like ornamental Indian corn. He's saying another means by which you determine the subject matter of a law is to look at the immediate context of that law. So the circumstances in which it was written, which would include the society in which it was written. He doesn't say all this in his article. This is sort of implied. I don't know how he expects you to infer this if you aren't familiar with Blackstone, but I guess he sort of does. And what he's saying is to determine that context, you want to look at contemporaneous expressions. That's the word he uses, right?
He says contemporaneous construction or contemporaneous exposition.
That's right. So exposition or construction, contemporaneous exposition or construction. That makes sense. Obviously, if we look at a text and it's ambiguous because we don't use the same language anymore, or we just don't know what they're referring to, you're going to want to look at people who were around at the same time and see how they would have understood it. That's what this contemporaneous construction is going to refer to. Now, where he makes a leap, in my opinion, is saying that means you ought to prioritize old cases over new ones. Because I guess the rationale there, the line of logic, is that old cases are going to be closer to the time in which the Constitution was written. There may be some truth to that. And I think certainly cases that purport to do that are going to be more authoritative than newer cases. But I think really the most relevant application of this contemporaneous construction rule is going to be, who do we look at for who a reasonable interpreter of the Constitution would have been at the time of its ratification? Well, state ratifying conventions, right? He totally ignores that aspect of it. He's saying, when you're looking at contemporaneous constructions, you ought to be looking at cases, but we actually have the very people who are entrusted with ratifying this Constitution. We know exactly what they understood it to mean when they were ratifying it because they kept records of their conventions.
Within limits, but yeah.
I mean, we've got like a 100-page transcript of what
Patrick
Henry had to say in Virginia.
Yeah, and that can make it pretty clear, but we have a whole thing about, you can look up one of our videos. It's called how not to read
the minds of the founding fathers. Yeah. Although I think we may be changing the title of that one. But
okay. Anyway,
we do have a video on this.
The conclusion was you can't read their minds, but what you should do is
But you shouldn't read their minds either.
Yeah. You should look at, the documents, and there are tools that help you figure out what the documents meant at the time to the people who were, anyway.
Yeah.
All that to say.
But the significance, so Blackstone did not live in a constitutional republic like we do. He was not looking at enactments that had been ratified by the people. He was looking at enactments that had been passed by Parliament. What's unique about our Constitution is that it's a compact. It had to be ratified by the states. It's essentially a contract. And if you know how contracts work, there's got to be a meeting of the minds. Both parties had to understand the same thing when they put their pens to paper. And you can look at extrinsic. You want to look within the four corners of the document to determine that. Generally, you're not going to allow parole evidence, but you're going to look at different things when construing contract language as well. Like if it's a construction contract, you're going to look at construction terms. So I think really a relevant part of this consideration is going to be looking at exactly what the people thought they were getting when they voted on this thing. And that's going to be the state ratifying conventions.
Yeah. So all that to say, you're not exactly on board with his particular sort of candidate for the one true originalist method.
I am on board with the Blackstonian method.
Yeah,
I think that the Blackstonian method is the correct method for originalism. I don't think he's correctly identified the Blackstonian method. I think that he's sort of actually been a little, I don't know if it was intentional or unintentional, but he's been a little bit deceptive about what he's doing. Because he says, we should unite around the Blackstonian method, and then just makes a huge leap to, well, that means X, Y, Z.
Yeah, but you're probably not on board with the details of this essay. But one of the things that I thought...
I will say I am on board with the idea that older case law binds newer case law. Mm-hmm. I think that by nature of what case law is doing, if you have judges who are properly making the sort of opinions they ought to, which is far from a given in constitutional law, but I'm saying, in an ideal world, if judges are making the sort of rulings they ought to, the newer rulings are going to have greater specificity than the old ones. So of course you're going to cite the newer ones. That doesn't mean they're more authoritative than the older ones. In fact, the older ones are more authoritative.
Because
so when deciding whether or not to overrule something, you're going to be much more likely to overrule a new thing than you are an old thing.
Right.
But if you're looking daily, run-of-the-mill, assuming this isn't supposed to be overturned, you're probably going to look at newer cases.
Yeah. So fair enough on that point. One of the things I thought was an interesting, question to consider, raised the question, did not beg the question, that of whether or not it's really necessary to push for, one originalist way of doing things. Or whether there's...
And I don't think there is.
Yeah,
I really don't think
there is. Whether there's room for... because I think...
One of the biggest criticisms of originalists tends to be you only accept people with your same interpretive methodology. And if they don't have that methodology, you just call them a bad judge. I would say actually being a judge is synonymous with originalism, because you're not supposed to be voicing your own opinions. You're supposed to be looking at the law says. And all that originalism really stands for is the proposition that the law should do what it was supposed to do when it was enacted.
Yeah.
Now, there can be any number of different means of going about determining what that is. And I'm fine with pretty much all of them. We can have reasonable minds differ on that. I would accept any of those people as upstanding members of the judiciary. But, of course, I do have my own opinions about how originalism ought to be applied.
Yeah. I think it comes back in many ways to a principle we've talked about repeatedly on this podcast already, that what you're looking for in law is often above anything else just consistency of application. You want to be able to determine how something will be applied so that you can know, am I violating the law or not when I do this? And I think to a lesser extent, that's a really, really important quality for individual judges to have. Like, obviously, individual judges shouldn't be in a position to influence the whole system, but you'd want to be sure that a given judge is likely to rule similarly in similar cases. And I think one of the ways you do that is just by being consistent with your own interpretive method. I think that, it makes sense that there would be differences.
English McClellan's fairly imprecise about how he would actually apply this methodology. I don't know if what he envisions is that in disputes people would only cite very old cases. But if that is what he envisions, that's something that would lead to a great deal of uncertainty in outcomes of cases, because you would never resolve issues. You would never be able to move past the same argument they had in Gibbons v. Ogden. We would just always be about whether or not navigation is commerce. You couldn't get to whatever the next. I should not have picked Commerce Clause. That's the exact area where the court decided not to act consistently with what the Constitution said. But
but as you said earlier, actually, I think there is a sense in which always going back to the older cases undermines their authority, because in theory, if they were operating authoritatively and correctly, they would just set the parameters for later decisions to fall within.
That's exactly correct. That's exactly correct.
Yeah. So like if you've already built the dance floor, you don't need to look at the planks. You need to look at, the steps people are doing. That's how you would judge the dancing. So
let's look at this in abstract. You've got cases 1, 2, 3, 4, and 5, and those are in chronological order. Case 1 was in 1789, case 2 was in 1810, so on and so forth.
Yeah.
If you're arguing in a case, if your opponent says, look, the conclusion you're arguing for doesn't agree with case 5, I think it is an acceptable, valid, correct way of arguing to say, it may not agree with case 5, but it agrees with case 4. And case 4 is what case 5 was based on. And I would say if that's what Angus McClellan means by older case law is more authoritative, 100% he's correct. Because if case 5 is based on case 4 is more authoritative. And then if they want to come back and say, okay, well, it may be based on case 4, but it doesn't agree with case 3, I should be able to come back and say, well, it may not agree with case 3, but it agrees with case 2, and so on and so forth. That should be a valid way of arguing about this.
Yeah. Anyway, we've probably gone on long enough about that, so we're going to get into...
We got an awfully abstract... Judicial philosophy, interpretive philosophy, methodology is always going to be pretty abstract. It's very important.
Yeah.
I've got a lot of opinions about it, as I'm sure you can tell, but... may not be everyone's cup of tea.
No. But anyway, so we're going to move on to our main topic of conversation. We probably ended up spending about as much time on that last one as we will on this one. But last week...
And actually, this one relates. This one directly relates because, remember, our thing was about whether or not laws produce predictable outcomes. Well, take it away, David.
Yeah, so last week...
I've said that a lot today.
We spent... it could be a catchphrase. We spent a lot of time on a recent case that involved the SEC and specifically the SEC's administrative courts. And among other things, we were talking about, what are these regulatory bodies really about? What are they up to? How do they work? Anyway, we alluded
if you don't know what administrative agencies are, look at last week's podcast. I don't want to repeat everything we said about administrative agencies last week. This week, our focus is going to be a little bit more narrow. Specifically, I think we're going to look at how we got here.
Yeah, well, so a couple things that we wanted to hit. One, how did we end up here? If regulatory bodies have all these issues that we talked about last week, how did we end up here in the first place? And in addition, we wanted to talk about why is this something that we, came up with? What are the alternatives to a regulatory-based system? And, how would that work, basically? Because I think one of the things that makes people very cautious when it comes to deregulation is the idea that suddenly things are going to be unsafe, uncontrolled, etc. And that's not necessarily
If nobody
valid.
tells them not to put fingers in my sausages, I'm only going to get sausage fingers.
Maybe we should try to come up with a new
Finger
analogy.
sausages, rather.
Yeah, maybe we
People
should
didn't
try
like
to come
that
up
one?
with a new analogy versus, I think, it's fine, but we got comments that we kind of used the phrase finger sausages a lot last week. So maybe we'll just come up with something different. But
Let's see, what else? They regulate virtually everything, so we could use something else. Maybe.
yeah, they're afraid that their Kool-Aid will be gasoline or something, I guess. I don't know.
Well, they do. It's got to be only 30% gasoline.
Yeah. I'm worried that if the FDA doesn't make it very clear to the Kool-Aid Corporation, I don't know who their parent company is. I'm sure it's not Kool-Aid Inc., but if they don't make it very clear up front that you can't put more than 1 part per million of gasoline into this drink, that you're breaking the law.
You got to go to French Guiana if you want to do that.
That's a little dark, and that wasn't actually Kool-Aid. For those of you who may be interested in Jonestown and the Jonestown tragedy, they were not drinking Kool-Aid; they were drinking knockoff Kool-Aid called Flavor Aid.
So don't drink the Flavor Aid.
Yeah, that should be the expression. Yeah,
the Kool-Aid's fine.
Yeah, the Kool-Aid is the superior product. We're probably gonna have to cut this.
The Kool-Aid should make an ad campaign. Not the beverage used at Jonestown.
Yeah, well, has never been used in a mass
suicide.
Yeah. Anyway, so let's get into it. So I'm going to start with,
and they regulate all kinds of things besides food. They regulate basically anything. The air, the air we breathe, the water we drink, the thoughts we think, the everything, every aspect of human life. I think food's particularly easy to understand because I think it's a little bit more relatable about why you might want to have laws about that, and it's not going to be something that's really complicated like a lot of the business regulations. So it works well for examples.
But there's regulations on banking. There's regulations on machinery of all various kinds. Pretty much anything you can think of that there's a business that does it, there's regulations.
Even if there's not a business that does it. There's postal regulations. Actually, there are businesses that do that, I suppose. But
yeah. The question of where the regulatory state comes from can be answered sort of on 2 levels. One is where the specific American version comes from. And then one is more broadly, where does this idea come from in general? But why don't we start with the American regulatory state?
Yeah. In an American context, there's 2 real watershed moments for the federal bureaucracy. The first one is going to be the Civil War. And then really the much larger one is going to be the FDR administration. He served
New Deal.
At least part of 4 terms. He was in for a long, long time, 12 years, and that gave him a lot of time to do a lot of stuff. And part of this is, so we mentioned last week, at least in terms of non-delegation doctrine, so whether or not Congress can deputize an executive agency to make laws on its behalf, the standard on that comes from a 1922 case, and that's J.W. Hampton Jr. v. United States. And, 1922, this case really came at kind of an unfortunate time because you can see where this intelligible standard principle came from a court that was not terribly concerned that this was going to come up a whole lot or that this standard was going to be used all that widely. But then lo and behold, 10 years later, FDR comes into office, and J.W. Hampton ends up getting cited a whole lot. It's actually a Taft opinion. President Taft was Supreme Court Justice and Chief Justice, and he wrote that one. Kind of a fun fact.
Still the only guy, right, who has ever been both, as far as I know?
Yes, he is.
Yeah.
Yep.
He also, another fun fact, he used to sometimes golf at a course where I used to caddy as a middle schooler, and there's a particular sand bunker that they called the Taft bunker. Anyway.
Was it created when he fell or?
Well, no. Okay. So we will get it. All right. So Taft, famously very large man, very corpulent, let's say. The joke was that
another good word for the day.
Yeah. The caddies at this club kept a rope hidden in the woods near this particular bunker because its sides were so steep that he might have needed a hand getting out. As far as I know, that's an urban legend. Never actually happened. And to his credit, he got in much better shape after he was president, lost quite a bit of weight, got reasonably healthy. So good for him.
Good for him.
But he went through some periods.
Even as a Supreme Court justice to do that. That's commendable.
Yeah. But so the Taft bunker, the joke was keep a rope nearby in case you need to fish the president out. Anyway, FDR. We were talking about FDR.
Yeah, so just to be clear, this intelligible principle rule in the J.W. Hampton case looked at a case basically in which the president could decide what levels of tariffs were for different products, and said that Congress had unconstitutionally delegated to the president the power to set tariffs because Congress is supposed to set the tariffs. And that's where they say, the president was given authority to create contextual tariffs, and he was given an intelligible principle whereby to do that. So that's where we get that test. That test gets applied, everywhere but the kitchen sink during the FDR administration. At first, the court actually cites that principle against him. So really, we mentioned last week, there's been really no non-delegation jurisprudence for the past 80 years. The last two cases that really relied on this principle are going to be the Schechter Poultry case and the Panama Refining Company case. Both of those are 1935 cases. And what the Panama Refining case looked at was one of the provisions of the National Industrial Recovery Act had authorized the president to prohibit interstate and foreign transportation of petroleum. It produced in excess of certain quotas that he'd imposed. Because remember, part of the New Deal was to say that the reason our economy is so bad is that we just make too much stuff. Less stuff will make the economy better. So we're gonna regulate how much petroleum there can be. And it basically gave the president authority to decide whether or not he was going to prohibit excess petroleum. The court said that he couldn't do that, citing non-delegation doctrine. Next case is Schechter Poultry. That one's on a whole lot of other issues. But the big one is, so basically another provision of the National Industrial Recovery Act was that the presidency could consult with local boards, usually private boards, that had imposed regulations on whatever their industry was, and he could decide whether or not the executive was going to use and enforce those regulations. And famously, this is the sick chicken case, where one of the provisions that FDR had decided to enforce was one saying that you can't pick out your chicken if you're slaughtering the chicken. Chickens have to be slaughtered basically at random, but that applied to meat markets too. So you have to kind of blindly grab at chickens. And this sort of made headlines for a while when one of the justices was like, well, what if the chickens run to the other side of the pen? How are you going to do that? But anyway, that one ends up getting overturned as well. So FDR doesn't like it. He says, a lot of my New Deal isn't going through because of these stupid justices. So he introduces to Congress a scheme to pack the court, where they're going to add a new justice for every justice over the age of, I think it was 70. This is very, very unpopular, wildly unpopular. Court packing schemes have always been among the most unpopular things you can do in this country. People really didn't like it. FDR nevertheless sticks to his guns on it until Robert Owens. I'm sorry. Owen Roberts, Judge Roberts, decides that he is, engages in the switch in time that saved 9. And he, rather than voting to strike down New Deal policies, begins upholding New Deal policies, and FDR drops his court packing scheme. And non-delegation doctrine is not really used again by the court after this until a court case that I wrote the brief on, by the way, on behalf of the Center for Constitutional Jurisprudence, Gundy v. United States. And this ends up being the turning point, where once again separation of powers begins to be upheld by the court, and justice and rule of law are restored throughout the land.
And
we're still in that process of restoring justice and rule of law throughout the land, but that's the turning point. Now I think that was a 2019 case. Non-delegation is now a live doctrine where cases can be litigated again. This has not been true since FDR bullied the court into dropping that doctrine 80 years ago.
And so
the more famous effect of the switch in time to save 9 was that things stopped being struck down on Commerce Clause grounds. That's the one you hear about. It was both. Commerce Clause is certainly the more famous of the two. The reason it's more famous of the two is because that's become a live issue again as well, but that became a live issue quite a while longer ago. 1995 case. It's the Lopez case, which held that, hey, banning guns in schools has nothing to do with commerce. You can't do that. And that sort of made Commerce Clause a live issue again. But now non-delegation, which debatably is the more significant of the two doctrines, is back on the table. So there's your summary. That's probably more than you wanted, David.
No, that's fine. Especially because in many ways, sort of the lifeblood of the, I don't want to say regulatory system, but the regulatory agency system, sort of the actual apparatus of government, has been the abeyance of the non-delegation doctrine. Basically, as long as people weren't prepared to really consider it, or weren't prepared to do more than just sort of say, yeah, blah, 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 whatever. We have a law saying we're in charge of this stuff now. That's what really let the agencies sort of thrive.
Yeah.
But
well, that's why I mentioned the case that established this intelligible principle rule was not anticipating this huge ballooning of executive agencies. You know, when you think you've got a relatively unimportant issue that's only going to be heard this one time, it's not going to come up again, human nature is to be a little bit less judicious in making sure that very clear standards are articulated. That's how we got this intelligible principle rule. Really, our organization advocates for the replacement of that rule with one that's actually judicially able, I guess a more judicially manageable standard.
Yeah.
One that it's clearer which things run afoul of it and which things are consistent with it. Because we need one. You know, we've got a lot of executive, like I said last week, if you picked out letters at random from one of those lottery machines, my bet is if you picked any three, you're going to get an executive agency.
I think a lot of the sort of inertia that goes along with the acceptance of the agency system, sort of the way it is, that, you know, is that I think people have a couple different sort of ideas in their head. One is that this is sort of like, this is always the way it is and always has been, blah, blah, blah. That's one sort of way I think people think about it. It's just, this is what governments do. They make rules about everything. And I think another one, which is...
I think the more... You go ahead.
Well, a related one, but obviously incompatible one, is governments used to do nothing, basically, other than like maybe like make war. And then as we modernized, we started regulating everything.
Yeah,
and
these
so
are
that's
the needs of the modern world, is the one that I hear. They didn't need to do this back when people used...
Whatever.
You know, washed their clothes by hand and didn't have refrigerators. They didn't even have ballpoint pens. Now that we've got ballpoint pens, you've got to be able to regulate what can be called a ballpoint pen.
Yeah. A common one that I see...
You have to regulate how big the balls can be on them. You got to regulate how much ink they hold. That makes no sense to me. I don't understand why having more stuff would require a bigger regulatory apparatus.
Yeah. And, you know, this is even more absurd. And this is one is more generally just sort of like in favor of, you know, we don't need to care too much about the Constitution. But it makes absolutely no sense to me. The Founding Fathers didn't even know that dinosaurs existed, so why should we care what they had to say?
Actually, Thomas Jefferson's the guy who introduced the word mammoth as an adjective in our language.
Yeah.
Well, it's not a dinosaur, but they were certainly interested in paleontology. I mean, the actual guys who were involved in separating from Great Britain were themselves like the preeminent paleontologists of the day.
But
he just liked mammoth so doggone much that he used mammoth in his correspondence to refer to size, and people picked up on it. I mean, that's...
Setting aside, though, their personal interest in, you know, something I think it hasn't been released yet, but something we are working on makes note of the fact that lots of the Founding Fathers were deeply involved in lots of different kinds of organizations, including scientific societies, universities, etc. They had very broad interests, many of them. But anyway, setting that aside... I always have to wonder...
Washington really liked waterways.
Okay. But I have to wonder, why does it matter whether or not someone who designed a political system happened to know about the existence of dinosaurs? I'm not really clear what the connection is, why that would make you better or worse.
How could somebody who doesn't know about dinosaurs possibly make good laws?
Yeah, it's, you know, how could a guy who didn't know about dinosaurs possibly come up with a theorem for calculating the hypotenuse of a right triangle?
No, I kind of just repeat as sort of a shorthand for that whole attitude is, oh, well, of course that standard can't work anymore. We have refrigerators now. As if the existence of modern technology totally negates a principle that was true in the past.
Yeah, and one that, again, like the Constitution... really shouldn't have a lot to do with refrigerators because it didn't really go very far out of its way to grant any particular element of the government power over standards for machines.
Let's just take a second here. Okay, all right, I just want to speak to our audience person to person right now. You guys understand that when our founding fathers drafted our Constitution, they knew that our society would change.
Yeah.
They didn't expect it to stay static. In the actual debates in the Constitutional Convention debates where they are writing the Constitution, they make models and extrapolate what the population will be in the next 200 years. And they're, I think, within like 15% correct what they ended up being. They anticipate the idea there will be new states that are introduced. They anticipate the fact that we will be from coast to coast. They are not unaware of the fact that societies change.
Or even, technological change. They were, the Industrial Revolution had started by this point.
Oh, yeah. It was in full swing. Well, maybe not full swing, but
it was definitely going to accelerate in the 19th century. But in the 18th century, we're already at the beginning of probably the biggest technological boom that Western society had ever seen.
Has ever seen.
Yeah.
Like since then, too.
Yeah, I mean, we're basically still part of the Industrial Revolution.
Yes.
We're just, a little further downstream from it. But it had already started. They knew, they understood that things were changing at a pretty quick pace. And in fact, that's, I think, in some ways, one of the reasons they felt comfortable thinking, you know what, we can design a system of government.
Look,
there's that misperception, this idea that, it's just, this is what modern government looks like, got all these regulations. And I think that shows a certain amount of historical ignorance. And, this isn't super important to the American form, but I think it bears noting. These sorts of industry regulations were actually a hallmark of the pre-modern world. Medieval guilds were very active political players.
Or even if you go back to ancient Egypt, you know why language was really invented? And I know some people say cuneiform, however you want to say it, is older, but you know why at least hieroglyphs were invented?
No, go on.
Government record keeping.
Yeah.
You call them hieroglyphs, so you assume they're for the hieratic, the priestly order. But really, our oldest records are on, bottles of stuff, taxation records. They would track how high the Nile went every year because the Nile inundation was the principal thing that would affect how big the harvest would be. The reason they wanted to track how big the harvest would be is so they could set tax rates based on it.
Yeah.
If that's not an administrative agency, I don't know what is. That would require an office of Nile record keeping. It would require an office of taxation. These offices would need to coordinate with each other. That's the only way to accomplish that.
It's a theme for a very long time, especially because the pre-modern world tended to treat law and rights more in terms of groups that they attach to rather than individuals.
Yeah, that's one of the novel things. Ours is the first to really set in stone or on parchment that concept.
Yeah. Yeah. But so you would have, say the Guild of Bakers, and they had a certain amount of political influence because there's there's a certain number of them. They've got some money. They they can make life hard or easy
the Lollipop
for whoever's...
Guild in Munchkintown.
Yeah, but so the
we
Bakers
see how
Guild,
corrupt they were.
Yeah, and the the Bakers Guild
you don't like my
can
sense
go
of humor.
Not always. The Bakers Guild can go to the king or whoever's in charge and say, you know what, we want you to support us in keeping out people who aren't part of our guild from baking bread. So you might directly say you have to be a member of the guild to bake in this town.
Yeah, or even, we want to make sure that all of our grain is locally sourced. So we want you to say that any baker that doesn't bake with grain that has your stamp on it cannot register as a banker in this city, or a baker in this city.
Yeah. And so there's more direct forms like that. And then
those were the more common, I think.
Yeah, and then there's certain more indirect ones. So it's like, only doing it this way is approved, and we keep the secrets of how to do it.
Or there may only be 12 steel smelting furnaces in this city. Yeah. So what does
artificial
that mean?
limitations on the number of competitors, and you need a definition. Okay, what is a smelting furnace like?
Yeah, so somebody makes a new one that doesn't use the same technology as the old one, and the response is generally to say that's an illegal steel smelting furnace. The response is generally to say that's an illegal steel smelting furnace. Yeah.
Yeah, and that sort of mentality goes hand in fist with, monarchy, with sort of more centralized forms of government for a very long time until eventually...
All of the ancient tyrannies did it. I mean, our knowledge of the ancient world tends to refer most often to ancient Rome. Well, ancient Rome was a lot less bureaucratic than the states that preceded it. If you look at ancient Egypt, ancient Mesopotamia, even ancient China, they're basically ruled by bureaucrats. I mean, even the modern Chinese language, not the simplified one that is supported by the Communist Party, but the traditional Chinese language, highly bureaucratic.
And it's not until the sort of expansion of the European markets after the Black Death. So that's a whole other topic. But basically, it reaches a point where people are like, you know what? No, we realized all this stuff was sort of stifling our industries and our economy. Around that time period, though, so early modern era, that's when we really actually start to see the first deregulation. And that's actually the newer thing then. It's not coincidental that it happened to go with some of the most prosperous times Western society had ever seen, in my opinion.
Yeah, so all of these bureaucrats really just need to get with the times. I mean, what they're doing is way too third millennium BC.
Yeah, no, and so
they got to get with the times.
It's not a logical argument that people make against deregulation to say that it's, old-fashioned. That's not actually directly relevant, but I think that has a lot of...
But they're wrong about it anyway.
Yeah, that has a lot of heft for certain people who don't want to feel like they're turning back the clock or whatever. But I think it's important to realize, all this sort of ultra granular bureaucracy is in some ways millennia old throwback, Yeah.
Well, and it's similar too, because part of the ancient Egyptian mythology. Sorry, I've been reading about Egypt recently, so
I can tell.
It's on my mind. But part of that mythology was that the Pharaoh was charged with basically upholding the natural order of the cosmos, keeping the seasons in their natural order, making sure that the Nile would inundate at the right times, all that sort of thing. So my bet is if you'd asked an ancient Egyptian, well, why do you need Pharaoh? It would have told you, well, we need to make sure that the Nile inundation happens at the right time. That's pretty dang important.
Yeah.
Same way if you ask somebody, why do you need food regulation nowadays? Well, we got to make sure there aren't fingers in sausages.
Yeah. Or gasoline.
Well, it turns out there's
Kool-Aid.
actually other things that might prevent that from happening, totally irrespective of Pharaoh's influence.
Yeah, and so good transition. I applaud you. Let's talk about what are some of the potential alternatives, and in fact, actual alternatives that we used to use to the regulatory state.
My favorite one is nothing. We
Right,
used to do nothing on a
but
lot of this stuff, and
when you
everything
say-
worked fine.
When you say nothing, we don't literally mean, because the thing people are afraid of, and I understand why you'd be afraid of someone suddenly deciding, hey, we figured out it's cheaper if we make Kool-Aid with gas instead of Kool-Aid. So we're just going to start selling a bunch of people.
With gas, not right now. I mean, maybe a year ago.
Fair enough.
Right now, it's more expensive. It's cheaper to fill your car with champagne than it is with gasoline.
That's probably true. But anyway, okay, so
I know, I've done
turpentine. Or turpentine, excuse me.
It doesn't work
Turpentine.
well. Gasoline works better than champagne.
Yeah.
I haven't actually done that.
Okay, so let's say turpentine instead of gasoline. Then we're gonna make Kool-Aid with turpentine because that's cheaper and we'll make more money because we're an evil corporation. Blah blah blah. Whatever. Whatever people are afraid of happening. Well, I think a lot of people think without regulatory bodies to say no, there's a law against that. You can't do that. Then you have no recourse if someone does feed you turpentine, and that's not the case.
Yeah. We talked about that last week too.
Yeah, well, we alluded to this last week, and I wanted to go deeper into a couple specific things. Obviously there's fraud, and we were talking about fraud specifically last week. But I also want to talk about
there's also product liability. If you actually, even nowadays, although we probably have our issues with that, but you don't even actually have to be in privity with the original producer or the seller. The mere fact that you are the last person in the string of commerce to be able to receive this item is sufficient to make its producer liable to you. And if it has defects that result in injuries to you, you can receive compensation for that. That's a common law rule. Nothing that has anything to do with the regulatory state.
Yeah. And one of the things I think people don't seem to quite grasp is the part that torts play in general in our legal system. I think everyone thinks that to stop a bad thing from happening, like the only way the law can do anything about a bad thing is if it makes it a crime to do it. And
okay. Actually, I'm going to talk about Blackstone again here. So Blackstone, I think rightly, says the civil law, the government law, has to do with two things. It has to do with rights, and it has to do with wrongs. Mm-hmm. That's it. Rights and wrongs. Rights are things that are right for you to do.
Yep.
And wrongs are things that are wrong for you to do.
I put that one together myself.
So that's what the law's about. It's supposed to prohibit wrong, and it's supposed to permit right. And it works sort of the opposite way in which the Constitution restricts the government. If something isn't mentioned in the law, if it isn't restricted, then it's a right. It's a freedom of action. It's something that you can do. Wrongs are things that are actually prohibited under the law. And then you break that down. So you look at the wrongs side of it. There's two different kinds of wrongs. There are private wrongs and there are public wrongs. Public wrongs are things that are wrong to do to society in general, things that are wrong to do within the civil sphere in which you live. That's things that we usually deal with under the criminal code. We've made them criminal. That's why when there's a criminal proceeding against you, it's the state of whatever versus you, or United States versus you. That's the reason the case looks like that. Yeah. Private wrongs are things where society doesn't have a real stake in it, but two folks do. Yeah. The person who alleges the wrong against the other and the person who is alleged to have committed the wrong. And those cases are usually so-and-so v. so-and-so. That's it. That's what our law, that's it. It's, for whatever reason, people get very, very fixated on this public wrongs side of things, while ignoring the private wrongs entirely.
Right.
Even though we live in a society in which individual rights are prized, private wrongs ought to be taken, and in fact are taken very seriously. They're just dealt with under the civil law rather than the criminal.
Yeah, and so to, draw the line between the dots, say there's no regulation that specifically says Kool-Aid Company, you can't put turpentine in the drink and sell it to people because that's bad. Now, if they nevertheless do put turpentine
I really don't think it harms society when turpentine is in Kool-Aid. I think it harms the people that buy the Kool-Aid.
Well, but it would. So say you bought the Kool-Aid, and relying on the fact that Kool-Aid has historically been a very sugary drink that some people like, that I personally don't care for. But, say,
it's not turpentine flavored at all.
Right. It doesn't taste like turpentine, I can tell you that. And historically,
not at all.
When I have consumed Kool-Aid,
not even a little bit,
I have, not been at least immediately harmed. It may be contributing to diabetes I'll develop later down the line, but it didn't make me.
Which could be actionable as well if you couldn't reasonably have expected the diabetes, which you probably would. But
right. But so, if relying on my past experience with Kool-Aid, which is that it's a relatively harmless sugary drink, I pick one up.
Or other people's past experience, or what they've put out in their marketing.
Right.
They have that big guy and oh yeah.
And he doesn't say anything about turpentine at all.
He doesn't say anything about industrial solvents.
Yeah.
Like, it's nothing about that commercial implies that I am buying something that is in part or in whole industrial solvent.
Yeah. But so I buy it at the store, I take it home, I drink it, and ignoring the fact that it doesn't taste right, I consume it, and then I realize, that didn't taste right, and I become violently ill.
I don't think you'd realize that for long. I think you...
No. But somehow I managed to choke down all of it instead of just immediately spitting it out, and I become violently ill because of this, and I go to the doctor. Yeah, and it turns out, you consume turpentine, and it's gonna, cost you all this money in medical bills, et cetera, et cetera. Even without a regulation, there is recourse for me to have that wrong dealt with.
I think you could probably get punitive damages on that one too.
Yeah,
I don't think. You could get your medical bills covered. You could get your lost time at work covered. I think you'd also get, just a slap on the wrist from the court saying, you guys shouldn't have put turpentine in Kool-Aid. No, and punitive damages are often, I think there's a limit in California. I'm going to get it wrong, but it can't be however many times in excess of whatever the actual damages are. But all that to say, punitive damages are often much more than the actual damages.
Right. And so if Kool-Aid decides to make a practice of selling this turpentine drink, then they're probably going to end up with a lot of people bringing action against them. They're going to end up owing
even a class action, perhaps.
Yeah, and that can be extremely cost prohibitive for them. Whatever they hoped to accomplish or save, I don't know. I don't know if turpentine's even cheaper to produce than sugar water. Probably isn't. But imagine that it were, and they were hoping to make more money this way. If they get action brought against them consistently, which they would, it's not going to work for them. It's going to go away.
The issue you get are cases like with the Ford Pinto. I don't know if you know that whole thing.
Yeah.
Where Ford had made a cost-benefit analysis saying that the amount in lawsuits that the explosion of these cars was going to cost was less than the cost of fixing whatever the problem was.
Right.
But that problem does not go away when you regulate it. In fact, I'd say that problem is a little bit worse when you regulate it because you don't just have that kind of cost-benefit calculus some of the time. You have it every time.
Right.
Because every time somebody that runs a company sees, hey, we can meet this regulatory minimum, even though we know for a fact it is not safe for our product, they have every incentive to make that decision because then they're they're functionally immune from lawsuit on that. Yeah.
Well, and, even aside from the, genuinely meeting the minimum, if someone wants to be really nefarious, really malicious, and just, engage in deceptive practices, they can still do that with regulations. VW had a huge thing a few years back, Volkswagen, which is a massive company. I'm sure they spent a lot of resources on figuring out if cheating the emission standards which is what they did. They were required to have certain fuel efficiency basically for their cars, and they faked results. I guarantee you they considered the cost benefit of, what if we get caught for this? What are the regulatory penalties we would face? And they still determined that it was worth doing it. That problem doesn't go away either.
And see, I just know we're going to have people who listen to this and say, well, the solution then is higher regulatory penalties. We're not hard enough on these corporations. And you have missed the point.
Yeah.
We can't possibly know what people are going to produce in the future and how much it's going to cost them to do it. People are very creative.
Right.
People will find lots of ways to do things so they can make money.
Yeah.
That's why if you have a judicially enforced standard where somebody can seek punitive damages, and then a lawyer who is very familiar with the case will argue, here's the amount of punitive damages that I think will discourage this behavior in the future. See, like a real famous case that was kind of derided at the time.
The McDonald's hot coffee
The
thing.
McDonald's coffee,
Yep.
yeah, where the woman spilled hot coffee on her lap and it gave her third-degree burns. She had to get reconstructive surgery, all kinds of stuff. Much hotter than coffee is reasonable to be. But she was given millions and millions of dollars for this. And everybody said, that's absurd. She shouldn't have been given that. Reason she was given that is a lawyer argued and a judge imposed punitive damages equivalent to 1 day's coffee sales from McDonald's coffee.
Yeah.
That was what they reasoned was sufficient to discourage doing this. She got the full value of 1 day's sales of coffee at McDonald's.
Yeah. And I want to clarify,
I'd say it's probably low. I'm not sure 1 day really would discourage it.
No, and I want to clarify because I think a lot of people, in a bit of an irony, because normally people are very hard on corporations just out of principle, but this was one of the few times where I feel like people were like, poor McDonald's, so what? This dumb woman spilled coffee on herself and now they're at fault. They had a policy, as it was discovered, of maintaining the coffee at a dangerous level of heat so that people wouldn't be able to tell as easily when it had gone stale when they sold it to them. So you could basically keep the same batch of coffee around for longer by keeping it at a dangerously high temperature. And
so it was intentional.
Yeah, that's one of the reasons why she got severe burns is because they were deliberately keeping the coffee too hot.
Yeah, punitive damages are hard to get, just to be clear.
Yeah.
It's
and with good reason.
Because it's a punishment, punitive, it's a punishment. The standards for meeting that are higher than just general civil liability. It's closer to like a crime. So you've got to be able to show, if not intentionality, then malice. Malice has a legal meaning, it's intent or with reckless disregard to the consequences.
Yeah.
Usually those, but you need circumstances that show something really bad was going on.
Yeah, this wasn't just an honest mistake of some kind, basically.
Please don't call me and ask, here's my case, I can get punitive damages, right? It's like, well, even though I had no monetary harm here, I can get punitive damages, right? Probably not is the answer. I will seek punitive damages in lots of cases, never ever count on getting them. Odds are against it, even if you get a really, really good lawyer who makes the best possible case.
Yeah.
You should never stake your entire case on getting that. It's not legal advice, but...
Yeah, again, as we've said before, don't take any legal advice from a podcast. It's just a bad move in general. Don't care who's on the podcast. Don't do it.
Yeah. That's if you go through Blackstone's canons of interpretation, a guy on a podcast told me doesn't even make the list.
Yeah, I was going to say, I don't think that would appear, actually.
No.
And, the legal minds behind our Constitution may have anticipated societal change. I'm pretty sure they didn't specifically anticipate the podcast as a medium. So
I don't think they would have included it in their judicial philosophy if they had, David.
That's valid. That's a fair point. All right, we'll go now into our final segment. And those of you who have listened to previous episodes know we've tried a different name for this segment every time. That tradition will continue. But this time, I did not come up with the name, where, we crowdsourced some things and someone else at the Institute.
Maybe it'll be better this time then.
Someone else at the Institute. Well, actually, to be fair, they didn't say this exact thing. They said something very much like this, and I tweaked it a little bit to bring it more to where I wanted it. But this time around, we're calling it jalapenos. Like jalapenos, but with law instead, because these are spicy takes about law from the internet.
Who recommended that? Who recommended that?
This was based on a suggestion.
I might have to have it.
Based on a suggestion from Eric, although I think the original sort of prompt to go, I'm pretty sure that Kristen said something about a fairly similar idea. So anyway, blame them, not me. I am not weighing in on my
I'm still going to blame you. Still going to blame you, David.
Anyway, this is where we're going to take a look at some of the more interesting hot takes.
Jalapenos.
Jalapenos.
The last three have been food related.
It's, again, like, in terms of, if we're sticking with that hot takes motif, most of the time people are talking about heat.
What about the blast furnace? Call it
Well, but that's, I don't know. That's somehow less fun. I don't know. Anyway.
Well.
At some point, I'm probably just
like,
going to give up on coming up with a catchy name, and we're just going to call it
the
hot
smelting
takes.
plant, or
the Crucible. Actually, that's a pretty good one.
Yeah, that's pretty good.
Yeah.
Especially, that's already a legally related play by a communist.
Arthur Miller.
That's right.
Anyway, so now in response to
not an accurate play at all, by the way.
Yeah, no, there are a number of historical inaccuracies about that play, but Arthur Miller, fun fact, he was briefly married to Marilyn Monroe. Anyway, last week you complained a lot about them all being from Twitter, so this time I think none of the ones I've selected are from Twitter.
Good.
We'll see
Perfect.
how that goes. They may not be as good is the problem.
Nothing wrong with Twitter.
We'll find out.
Variety here.
Yeah. Well. Anyway, so let me pull up the first one here. I don't even remember what most of these are, so I'll be relearning them along with you.
They'll be lukewarm takes from David.
Anyway, so I censored a curse word here.
From?
That's what this I want to say was something that I clipped off of Reddit.
Okay.
I'm pretty sure.
So here,
I think several of these might be Reddit.
I went back several times because Paramount Plus kept messing with the screenshot. Bleeping with the screenshot. So I heard it about 6 times. I just went back again and listened 3 more times, and he is saying calm. Also, if they can't properly caption their own content, they're going to get sued for ADA noncompliance very soon. It has been becoming a big issue recently.
So this person, I don't know what show they were trying to watch.
This relates to what we've been saying about the administrative state.
Yeah.
Well, he got the wrong alphabet agency, for one. That's failure to properly caption this. I'm sure you could find some lawyer who, for a big enough retainer, would be willing to take the case that that's ADA discrimination. Don't pay that person, that retainer. That person's lying to you if they tell you can get a recovery. But in general, I don't think the ADA would cover that. Really, that kind of thing's regulated by the FCC. That's the Federal Communications Commission.
Yeah, and
different
ADA,
alphabet agency.
For the record, ADA, Americans with Disabilities Act. But so this person was watching some TV show on a streaming platform.
Also, the hilarious thing here is, so the ADA has to do with equal access to handicapped people of the same thing. Presumably, they're watching this content and can't hear what the person says, so they look up the closed captions, and they're saying that also might be wrong. If you can't hear it either, and the closed captions are wrong, that's equal access.
Yeah, it's just equally bad for everybody.
Right. So that's just a very
the
that's
Soviet
kind of
Union.
a facially, like a forehead slapper, because it's like, oh yeah, that was a pretty stupid thing for me to say. And I bet if they consider it for a few more seconds, I don't think this person is I think they're probably sharp enough to realize that mistake.
Who knows? But anyway, so I think we got your take there in the course of you describing it, but I'm going to go out on a limb here and say you don't think that failure to properly close caption a TV show is a violation of the ADA?
Like I said, you could probably find a lawyer who would bring that case. I wouldn't recommend it.
It wouldn't be you under most circumstances.
No, I would not. You want to pay me $200,000? I'm kidding. I would not take that case for any amount of money, because I have a fiduciary duty to my clients not to waste their money, and I would not take that case.
Yeah. All right. So. That's number one. Now, I cut this one down pretty heavily. This one, I think this is actually just like someone's group text that they ended up posting a screenshot of somewhere on social media. I don't even remember what site I got this from. But I'm only going to show you the last message from the screenshot. Suffice it to say, what came before was this guy describing criminal behavior.
Okay.
People, he was describing something he was planning on doing, and people were like, oh, you can't do that. That's a crime. And then he says this. You
got to go to the subreddit legal advice, because there's some horrendous stuff in there. But okay, so this is a text message. It says, I've done time for it once. I can't be charged for it again. Double Jeopardy. Oh, I love that. Oh, that's very funny. Oh, that's very funny. Okay, that's not how Double Jeopardy works. Double Jeopardy means that you can't be tried Double Jeopardy means that you can't be tried twice for the same offense. That doesn't mean
Right.
an offense rising under the same statutory code, or
Yeah.
it means the same offense.
Yeah, so it's, it's like, okay, I murdered this guy, right? And I went and I did my time. I did my 20 years or whatever, and I came out. Now they can never get me for murder again. And so I'm just going to go wild. That's what this guy seems to
Double
think.
jeopardy.
Now,
I've already faced a trial for murder, and it's my legal right not to have to do it again.
yeah. And one of the things I could have included, decided not to in the end, was this devolved into a long conversation on whatever the platform was. May have been Reddit, may have been Facebook, I don't remember. But about the plot of the movie Double Jeopardy, which I'm not sure if you're familiar with that one.
I've never even heard of that movie. I know it's a segment in
Okay.
the TV show Jeopardy. But
Well,
it just means
true
all
enough,
of your
but-
points are worth double or whatever.
Yeah. The film Double Jeopardy is about this woman whose husband fakes his own death and frames her for his murder. And then, she gets convicted or beats it. I forget what. But that first trial resolves.
Mm-hmm.
And then she finds the husband still alive and in revenge kills him on the theory that because she already faced the trial for his murder, she can't face it again.
That would not work.
Yeah, people on this platform, whatever it was, in response to this thing I just showed you, started arguing about this movie about whether or not that was legally accurate.
Yeah,
and a lot of people were insistent that it was.
That's the Double Jeopardy requirement basically applies when it's not even necessarily the same statutory section. It's even if somebody's charged with a different crime where the elements are the same, being tried under the same jurisdiction, and facts used to satisfy one element are the same between the different crimes. It's also going to run afoul of Double Jeopardy. It really has much more to do with the actual transaction that's at issue than it does with code sections. That's not really what that's about.
Yeah, but anyway, to put it simply, if you were, in this situation, if you were accused of killing someone who had in fact faked his own death, you don't then get just like a free ticket to kill that guy later.
No, that's
because if you then kill him later, that's not the same crime that you faced a trial for earlier.
Right.
It's a different crime because the facts are different.
In fact, you
It's a
were
different
indeed
circumstance.
properly acquitted that the time when you. It's like that was a proper ruling in that case.
Yeah.
I mean, it's like if you're charged with stealing the Cullinan diamond when you didn't, in fact, steal the Cullinan diamond, and then you're acquitted from doing that, you can't then go and steal the Cullinan diamond.
Yeah.
I mean, I'd hope that'd be really obvious.
I think in the movie she may have been convicted, and maybe they present that as like the key difference is that she'd already done time for killing this guy, or I don't know.
That
Something.
Yeah, I don't know. That may be true. The prosecutor would probably bring a motion to have the previous ruling reversed.
Yeah, you'd think.
I don't know how it would work in that instance. That's a good question.
Anyway, all right, so let's move on to the next one. And this one, I think I do remember the circumstances. I think this was on one of the law-related subreddits. And someone said, what's the craziest thing that you've had a client ask you for, or something, weirdest law story, basically, I believe from practicing attorneys.
Okay, so trying to get out of paying his bill at a restaurant because he ordered a single beer, which altered his mental capacity, thereby negating his capacity to enter into a binding contract when presented with his credit card receipt for signature. Now, the contract was created when he ordered the beer.
Yep.
You don't even get to any of the capacity arguments. The contract was created when he ordered the beer. It was just memorialized when they sent him the receipt.
Yeah, so nice, clean and simple one, I guess.
Yeah.
But I thought,
contracts,
points for inventiveness.
There's elements of a contract. It's got to have certain indefinite terms. It's got to have an offer. It's got to have acceptance. It's got to have reliance. I'm sorry, not reliance. It's got to have consideration. Or if not consideration, then it has to have reliance. All of those factors are present when he ordered the beer and the beer was brought to the table. So you don't need the writing in place for the contract to exist.
Yeah. But I do applaud the inventiveness here, though. I think this guy, he had a plan. He took a swing at it.
I would, except that I've gotten too many client consultations where somebody did something kind of dumb as a result of a basic misunderstanding of the law, thinking they were being clever, and got in a lot of trouble. I have, let me make this clear. We're a very, at LexRex Institute, we pride ourselves on being creative. We are always looking for sort of clever ways to approach issues, So I'm not at all opposed to people coming up with clever ideas to get around stuff. Sure, go ahead. Come to us with those. Consult us beforehand.
Yeah.
Not afterward.
And, I think it's probably no guarantee that you don't have a genuinely new creative solution to something. But when it comes to something like purchasing a beer, people have been doing that for literally thousands of years. And there's been, certainly at least centuries of legal reflection on things like that.
Contract law is about the most settled area of law. It's changed very little in the past couple thousand years.
It's probably unlikely you've discovered the trick to get unlimited free beer.
I'm not even going to get into the analysis of whether or not he could form the contract after drinking the beer. Let's not even go down that rabbit hole. But
Right.
he's not even strong on that.
All right. Anyway, so that's that one. And that brings us to our final one. I think this is from that same subreddit, same thread. People talking about interesting things they saw in their law careers.
A woman was going to take a course to obtain career skills. Her instructor died and she did not take the course. Then she was hurt in a roller skating accident and later tried to claim loss of income for the job she would have had if she had taken the course and successfully gotten the job.
So like a loss of potential earnings.
That's
claim.
pretty. You can get expectancy damages on things. They can't be entirely speculative, or they can't contain nested conditionals where if this had happened and this had happened and this had happened, well then I would have had the money. So you've cheated me out of it.
Yeah,
I think the test is reasonably certain to occur, and if you've got to meet a series of conditionals before something will be true. Not reasonably certain. In fact, this one was impossible to be true because her instructor had died. So just the opposite of being reasonably certain, it was 100% uncertain.
Yeah, so it put me in a few years ago. Was it a few now? I don't know. Time has basically become one undifferentiated mass to me since all this COVID stuff started.
That's not great.
But a little bit. Okay. So it must have been late in 2019 because it was pretty shortly before all the lockdowns started going on. But I was at a red light, stopped in my car, and this guy rear-ended me, totaled my car in the end. He was driving a pickup truck. I was driving a small sedan. And, I was basically okay. My neck was a little stiff for a couple of days. But this just strikes me as like, what if I had decided to go after that guy for, loss of income? Because I'm really convinced that if I hadn't hurt my neck that day, I was going to, really start an absolute world-class athletic training program, become a professional basketball player, and make $30 million a year. Yeah. And I'm going to sue him for that loss of $30 million.
No. If you were already doing that and you lost the money because your neck hurt for a few days.
That's how they get you.
Yeah. Now maybe what if the person was driving to a job interview and they got rear-ended, and because of that, they missed the job interview. Even there, you weren't reasonably certain to get the job. Even if there's a very high likelihood that you would get it. It's again, we call it expectancy damages for a reason. So we have consequential damage that's as a direct consequence of what the person did. We've got expectancy damages as well, which is things that you would expect. It's neither a direct consequence nor is it something that was an expectation. So you would not be able to be compensated for that.
All right. Well, I think we have successfully wrapped up all of our
I'm not saying you won't find a lawyer who will tell you that he can get this in court. I mean, the things that some lawyers will promise their clients are...
Did you know you have rights? The Constitution says you do.
And so do I. Yeah, you don't want to hire Saul Goodman. Maybe you do. I haven't watched the show. Maybe he's a good lawyer, but his ads don't speak that highly of him.
No, he's not a very good lawyer. Anyway, so that was How Law Peños. At least this week it was.
Yeah,
and
that's what that was.
That's gonna wrap it up for this week's episode. Thank you for listening. This has been a production of the Lex Rex Institute podcast, and we hope to have you come back.
All right. See you next week.